This podcast is for reference purposes only. It does not constitute legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances. Hello and welcome to Maddocks on the Mic. You're listening to Watchdog, where we discuss the ACCC's leading cases and regulatory activity and also discuss major developments in the area of competition and consumer law. My name is Shaun Temby. I'm a partner in the dispute resolution and litigation team at Maddocks. I'm also editor of our annual publication, the ACCC Year in Review. Back on the mic with me today is Maddocks Special Counsel Chris Marsh. As regular listeners will know, Chris specialises in competition and consumer law advice and litigation, advising clients on general, contractual and commercial disputes. Now, today we'll be discussing calls by the ACCC for reforms to Australia's merger laws. However, we're going to flip the script today, and for this podcast, we're going to have Chris interview me.
This should be fun. Let's do it. So ACCC Chair Gina Cascott-Lepp has followed her predecessor Rod Sims down this potentially treacherous merger reforms path, and some commentators have said this might go some way to completing her ascension from gun-for-hire competition lawyer to a regulator. A bit going on here, Shaun. Can you start us off by telling us what are the changes that the ACCC is calling for?
Yeah, happy to do so. Several major changes. Firstly, and most significantly, I think the ACCC are proposing to introduce a mandatory notification process for mergers that meet specific criteria. We don't precisely know what those criteria are yet. And this will be significant because under the current informal clearance regime, it's a voluntary process and parties aren't required to notify the ACCC of transactions. Regardless of the value of the deal or the size of the parties, it's really left to the parties to make a decision one way or the other as to whether or not they want to involve the ACCC, and significantly when they want to involve the ACCC. In addition to the mandatory notification requirement, the ACCC would also have the ability to call in or to notify parties that they have concerns about a proposed transaction, even if it doesn't meet the nominated thresholds that the ACCC will be introducing. The next significant change is that the ACCC proposed to revise the merger test. It currently prohibits transactions that are likely to substantially lessen competition, and they want to expand that to include a reference to the entrenchment of market power, so the materially increasing or materially extending a position of substantial market power for one of the deal participants. There are a number of others. There's an absolute prohibition on completion of these transactions until ACCC clearance is obtained. And there's a significant change in the shift in the burden of proof. So under the current regime, if the ACCC is concerned about a transaction and believes that it may substantially lessen competition, then it can tell the parties it's not going to approve the transaction, but parties can still go ahead. And it's then up to the ACCC to decide whether it wants to spend the time and the money to obtain an injunction to prevent that transaction from going ahead. And we saw an example of that last year, something that rarely occurs, but the ACCC are proposing to change that and instead have a law against such a transaction proceeding unless the ACCC has approved it on the basis that it won't substantially lessen competition, or alternatively that the public benefits are such that it outweighs the detriment that would occur as a result of the transaction.
So you and I have been talking for some time now about these reforms and questioning the extent to which the new chair, Gina Cascott-Lepp, may want to put her own stamp on things. Are these changes consistent with the changes that former chair Rod Sims had been talking about for some time, or do they represent a new spin on those?
Yeah, I mean, some of the proposals, such as the mandatory notification of deals and the moratorium on transactions going ahead without ACCC approval, those are consistent with the merger reforms proposed by Rod Sims in August of 2021. So some similarities.
So what are the differences then between Sims' approach and Gina Cascott-Lepp's new approach?
Yeah, I mean, not as much as some people were predicting. Some people were surprised that the changes were relatively minor. There were some changes, including retaining the public benefits tests and amendments defining concepts such as the entrenchment of power, but, really tinkering at the edges.
So let's dig down a bit deeper into some of these new proposed changes, not to bore our listeners with statistics, but the ACCC assessed over 450 mergers under the voluntary regime last financial year, and it only rejected one of them. So why are we talking about these changes now, and what reasons are sitting behind them?
Well, I think it's fair to say the ACCC believes the current merger laws in Australia aren't effective, that they aren't effective in preventing mergers that are likely to substantially lessen competition. In addition, Gina Cascott-Leib has said that she is concerned with the extent to which companies game the system. And so the introduction of a mandatory notification process is really designed to address that concern. It'll ensure the ACCC is made aware of all mergers that are likely to have an anti-competitive effect, and it will then allow the ACCC to intervene and to do so at a much earlier stage. The ACCC has expressed concern that they're sometimes brought in really late with really limited information, and they're put under significant pressure by the merger parties to wade through the deal or to do so on the basis of that limited information. And the ACCC is really saying that's unsatisfactory.
I mean, many countries have mandatory notification thresholds. Are these changes really that controversial then?
Not really, no. There are a number of countries. United States has an obligation to notify the Federal Trade Commission and the Department of Justice if certain size thresholds are met. And, it's really looking then at the size of the transaction and the significance of the parties involved to determine whether or not the thresholds are met. And it'll be a very similar proposal here in Australia. We've also seen mandatory notification requirements in the European Union, Canada, and various other countries. So no, while there's been some critical commentary surrounding this proposal, I think it's highly likely that this is one that we're going to see come into effect.
And what about the changes to the burden of proof?
I think these are much more controversial. You rarely see situations where the burden of proof is shifted. So my prediction is that change is unlikely to get up.
That sounds like a sensible approach to me. I mean, what's been the reaction then in academic circles, in media circles, in legal circles since this was first announced 3 or 4 weeks ago now?
Yeah, I mean, we've talked a little bit about the concern about the mandatory notification requirement. In addition to that, some commentators have suggested that the proposed changes will result in a significant increase in the number of mergers that are subjected to review. Given the numbers you cited earlier, I just don't think that's right. I think the suggestion that somehow this is going to lead to huge amounts of additional work and huge amounts of potentially delays and things of that nature, I don't think we're going to see that come to pass. There's been some suggestion that these laws will deter foreign investment in Australia, as companies may be reluctant to invest. Once again, I just don't see the validity of that. I mean, we've already spoken about the fact that these types of laws exist in a lot of well-developed countries, so don't see that as having any real significance. And then finally, there's a suggestion that maybe the ACCC is going to have too much power, and that could lead to unintended consequences. Yeah, once again, I just don't see that being a valid concern.
You touched on it briefly, and I think we should delve into this a little bit deeper and some of the concerns on the ACCC side. I mean, if there's going to be more mergers requiring review, that's going to mean more resources required for the ACCC. It might also mean some different merger timelines for people who operate in this space than what they're operating. Can we delve into that a bit more?
Yeah, I mean, we've seen over the years, every time the federal government wants the ACCC to do something, when they give them some special responsibility, the ACCC is pretty good at getting the funding that it needs. It's a well-resourced organisation. So I can see if this process changes and, they are looking at more mergers, that a necessary consequence of that will be the fact that the government is going to have to give them more money, and that will solve that problem. And yeah, in terms of merger timelines, it's interesting because lawyers who practice in this area will say, well, if it's a global merger, we're more focused on the US or the European Union because the companies have much larger presences there. Australia's a sort of small market, etc. So they will say that the reason why the ACCC is notified late has nothing to do with gaming and has everything to do with where they're spending their time and attention. So what this will really do, I think, is it will push forward the date of notification of the proposed merger in Australia, and it'll mean that that, those types of lawyers on those types of deals are really going to have to engage with the ACCC much sooner, and probably they're at around the same time that they're doing so with the Federal Trade Commission, for instance, or the competition regulator in the EU.
What about some of the concerns that have been floating around about it restricting foreign investment in Australia?
Yeah, I don't think we're going to see it being a significant deterrent to investment. I think that's a bit of a furphy.
Okay, well, having delved a bit deeper into some of those issues, where to from here? How likely is this to happen? What kind of timelines do you think we're talking about here?
Yeah, this proposal isn't moving quickly. Obviously, the transition from Rod Sims to Gina Cascott-Leeb has taken some time, but she's picked these merger reform proposals up from August 2021. Here we are now, May 2023. There's going to be a period of consultation with industry, with lawyers, the Law Council of Australia, bodies like that. But the reality is that the Attorney General is really consumed by the voice referendum. And so I suspect that we're not going to see any real movement on this probably until early 2024.
Any final thoughts before we wrap up?
Yeah, look, I think it's important to note that the proposed changes are still in that consultation stage, and that stakeholders have an opportunity to provide feedback to the ACCC. So once that happens and that process is completed, it will be interesting to see how the proposed changes to the law develop and ultimately the form in which they are implemented. Watch this space.
Excellent. Well, we might leave it there then. This has been a fun turning of the tables from my perspective. Thanks for everyone for listening, and we hope you enjoyed it. If you have any questions, please don't hesitate to reach out to myself or Sean. Our details are in the show notes. Thanks for listening.
Thanks for tuning in to the Watchdog series brought to you by Maddocks on the Mic. If you like this episode, make sure to subscribe wherever you listen so you don't miss an episode of the show. For more information on any of the topics discussed in this episode, please visit our website, maddocks.com.au.